Most everybody registered, so we're going to go ahead and get started. So the presentation today is on the new law that's allowing standalone HRAs for small employers. It's being presented by Biggs Insurance Services. My name is Tyson Fuhr. I'm going to be the presenter today. I'm the Vice President currently of Biggs Insurance for the Life and Health Department, and also since 2014 been working as the Compliance Manager here as well. My contact information is in these slides, as I mentioned earlier. Inside the presentation, or on the toolbar on the right that you might have minimized, is the option to download the slides. But we're going to record this session and send that out in case you want to listen back to it later on. But feel free to reach out to me or any of the producers here at the office or consultants at the office to be able to help you out. Next slide. So today's agenda, as I mentioned, we're talking about standalone HRAs. I'm just going to pause and say if you do have any questions along the way, we're going to try to answer them if possible. But today's agenda is about the history of health reimbursement arrangements. I'm talking a little bit about some of the changes that came up through FAQ 11 that was due to the healthcare reform or the ACA, and then also this new HRA option called a QSEHRA. So again, we're going to start with the history of health reimbursement arrangements. In 2002, there was a bulletin from the IRS, 2002-45. You can download the link if you want and read all the IRS information about it. But the short version of it is that HRAs were established as an employer-sponsored plan that allowed employees to be reimbursed on a tax-free basis for their eligible medical expenses. That tax-free reimbursement was also for employers, so it's a write-off just like premiums. And then again, it's not going to be considered income to the employees. These HRAs were funded 100% by the employer, which was a little bit of a deviation from what was available prior to this. HRAs, or a version of an HRA, was available underneath something called a MERP, Medical Expense Reimbursement Program, and an Executive Reimbursement Programs. And so they've been around for decades until this version of health reimbursement arrangement kind of stepped in and took over the new legislation. It allowed to reimburse up to all the 213D eligible expenses. So when you think of a flexible spending account or an HSA and all the medical, dental, and vision expenses that you can reimburse through that type of a plan, those are all the things an HRA can be used for. Most commonly, though, we're seeing them as a premium savings tool. Back in 2002, there were some pretty dramatic rate increases, a lot like we're seeing now with healthcare reform. 10, 20, 30% rate increases were pretty consistent with the plans that were being offered or being renewed back at the time. The economy was a lot better, or it was going in the right direction, so people were able to sometimes take on those increases, but they started to use these HRAs as a premium savings tool. We're going to show an example of how that looked, what that looked like, but it was a premium savings tool for their medical plan. So, shifting or reducing costs to the employer, but then also not keeping the employees whole, so that they didn't go from a $1,000 deductible to a $3,000 deductible and have to pay the difference. HRAs were commonly used to fill that gap. And again, we'll show an example here in a second. There definitely are some limitations on eligibility. My experience prior to coming to Biggs was I had my own third-party administration company. That one of our key plans that we worked with clients actually was health reimbursement arrangements. Did that for over 7 years, and one of the things that we found commonly was people that were ineligible for the plan were participating, and most commonly for that was owners. When you're dealing with an LLC or a subchapter S, meaning non-C Corp, 2% shareholders or more are not able to participate inside of an HRA. There is a rollover feature, and then there's also a retirement option. Neither one of those you saw too often, but that was actually one of the key things that the 2002-45 legislation brought in, or what they thought they were bringing in, was the rollover and the retirement choice. And the other thing is that, and this is something that a lot of folks weren't quite sure how to put this together, but a COBRA actually applies to an HRA. It's considered a group plan, an ERISA group plan, so you have to have a plan document, summary plan description, and you also have to offer continuation coverage of that HRA to an individual that experiences COBRA qualifying event or beneficiary. So that's when HRAs actually started, so back in 2002 officially. An example of what an HRA looks like, and this is a larger example, and it applies all the way down. I mean, there are groups, with 5 employees that are doing the same thing. But in this sample group segment, we're talking about an employer with 150 employees plus an additional 200 dependents or so. By reducing premium from going from a $250 deductible to a $1,000 deductible, reimbursing the employees and the difference between that, so basically $750, there was a premium savings of about $197,000. In this actual live case, the scenario is that 125 lives satisfied the $1,000 deductible, which again, the HRA was bridging the difference between what the old deductible is versus the new, so that 225 lives were reimbursed $750 each, or a total of $168,000, which basically created a net savings of $30,000 to that employer. This is a pretty extreme case, and you see this probably more commonly when you have that low of a deductible from $250, because you just don't see those a whole lot now. More commonly, we were seeing deductibles around $1,500 up to about a $3,000 or a $5,000 deductible, and so the reimbursement rate was much lower than what the example is here. But this just is trying to satisfy and providing what an example might look like. Okay, I'm going to pause just for a second, see if there's any questions on that, or if there's anything else that you might be interested in so far. I think we're good. Again, this is pretty common. It's been around for a while. Here we go. Next slide. Okay, so what expenses for an HRA are not eligible? So back in 2002, medical expense not defined as eligible under the employer's plan. So again, a lot of times when we're dealing with an employer that is defining the HRA to reimburse the difference between, let's say, the deductible change, only those expenses that hit the deductible would be actually eligible. Anything outside of that would not. Even though you have the option of having all of those 213D expenses, when you define an HRA, you say this is what the plan is going to specifically reimburse, which is as wide as all 213D or all the way down to just that deductible difference. Okay. Medical expenses incurred by an employee or employee's spouse or any eligible dependents prior to the effective date of the program. So that's pretty clear and obvious. Only people that are enrolled in the plan in the HRA are eligible for reimbursement. You can't basically reimburse people for expenses when they weren't an employee or eligible for the plan. A lot of times health insurance is not in there. And then the other thing is that when someone's requesting a reimbursement that were denied, you can't obviously reimburse them or do anything special there. It is a self-funded plan, so the employer has a little bit of discretion, but whatever's in the plan document is what it's allowed to pay. Okay. Another couple notes about HRA that's really important. You can't use a cafeteria plan to fund them. So back before 2002, you might have seen something called a MERP, or Medical Expense Reimbursement Program, which typically meant that the employer was using what we see here as an HRA, but also using employee contributions through a cafeteria plan to fund the plan. When the HRA in 2002-45 legislation came out, it got rid of the option of using a cafeteria plan to fund them, and so that wasn't allowed. You can't cash out HRA. So if you've got an amount, as I mentioned before, there's option for retirement and also rollover. So you can't use an HRA and cash the thing out. And again, we're talking about what an HRA looks like when 2002 happened, not necessarily exactly today. So people have to have an eligible expense and be reimbursed for that specific expense. There's coordination rules with health FSAs, or flexible spending accounts. You can define whether the HRA or the FSA pays first. If no rules in the plan document, then the HRA pays first and the FSA pays last, which might be the preferred method. But typically what we're dealing with is that employees want to, whatever their elections are for their FSA, they want to make sure that they don't lose that money, right? Even with the rollover option that exists today, you still don't want them losing that money. So many times you actually see the FSA pay first so that the HRA can pay in second. But those are things that you would need to define if you had an FSA in place, or just let it default to the standard rule. There are non-discrimination rules, or Section 105 non-discrimination rules, which follow all the normal rules around self-insured medical plans. Basically, you can't let it be top-heavy. So back in the original days of HRAs or reimbursement plans, when you had an executive reimbursement plan, they were originally designed just for executives, so you could provide a special benefit just for them. The non-discrimination rules don't allow that for the most part. You have to benefit test it, and if you have someone that makes a lot of money getting a benefit more than someone that doesn't as much, typically you're going to fail that test and the HRA won't pass, which basically means any of those reimbursements are taxable to the employee and then also to the employer. As I mentioned earlier, HRAs are ERISA plans, and so you have to have your plan document and all those kind of things that you would have with a regular group plan. And you can also use an HRA with a high deductible health plan / HSA combination. You don't see them a whole lot, but mainly because you have to have the minimum deductible requirement met before the HRA can pay. Otherwise, it's going to disqualify the high deductible health plan and any HSA contributions if it pays first dollar. Okay. Again, we don't see a whole lot of those, but just wanted to bring that up. When healthcare reform was put into place, we were dealing with something called FAQ 11 that came from the Department of Labor. There was a clarification for the ACA market reform. As you recall, inside of the ACA, it said that there was no annual limits. Well, HRAs, by definition, when we think about the primary use, where it bridges the deductible gap from, say, $250 to $1,000, that has an annual limit. Okay. So HRAs were not going to be allowed whatsoever until FAQ 11 came into place. And so what it said was at that point, and this is back in 2014, is that HRAs had to be integrated with the group health coverage, which basically meant if the individual was eligible and enrolling in the medical plan, they had to be eligible and enrolling in the HRA. You couldn't have an HRA exist standalone by itself and then have the employee not be enrolled in it and be eligible for reimbursement. Okay, so pretty simple. Standalone HRAs were not permitted at that time, so that actually cut loose a lot of those HRAs that were existing prior to the ACA going into place. A lot of people are actually pretty excited about the HRA being an option because of guaranteed issue coverages. Now, there were kind of a limited purpose HRA that was outside of healthcare reform. Some examples of those are retirement only HRAs, so those are outside the ACA rules, and then also dental and or vision HRAs. Neither one of those or neither of those three needed to be integrated with the group health plan, so you could have them stand alone and be on their own to do their thing. But if you had an HRA that paid for medical expenses, they had to be integrated with the group health plan. Okay. Now, great thing is that the HRA was updated, or this new legislation in December of 2016 was passed with the 21st Century Cures Act. And it basically said that small employers, as defined by the ACA, that do not maintain group health plans are allowed to establish a standalone HRA, so an HRA that's on its own without being integrated, for plan years effective January 1st, 2017 and beyond. And so you can kind of see what QSE stands for. Another great acronym that makes it a little more complicated. But basically what they're allowed to do with the new extension allowed was it allowed employees to be reimbursed for out-of-pocket medical care expenses, which included premiums for individual health insurance policies. Okay, so that's a very big change to what FAQ 11 defined within the ACA. Some of the things that are really critical, though, is that this only works for small employers. And so inside the ACA, we're talking about employers that have less than 50 employees, full-time equivalent employees, are allowed to offer a QSEHRA. But you cannot do that if you have a group health plan and then you add this as an additional option for your employees to go to the exchange or to the individual market and buy individual coverage. You have to get rid of your group health plan altogether and then put this plan in place. Okay. Employers that are doing this, they have 90 days after this act was put in place, so after December 13, 2016 or March 13, 2017, to provide the employee notice that they have this plan in place. There is a maximum benefit under this plan. I'm going to mention that here in a second, what exactly that is. And there's a statement: the employee is applying for advance payment of premium assistance tax credit. The employee should provide the exchange with the information about the QSEHRA maximum benefit, because it may have to do with their premium share subsidy. Okay, so the employee has some requirements if you're going to be doing this, but that's not that big of a deal. Also, the statement: if the employee is not covered under the minimum essential coverage for any month, the employee may be subject to a penalty because of the current individual mandate, and reimbursement of the QSE might be includable as gross income. Okay, so this is the new HRA that's in place, and it's a significant change because now that you've got individual coverage today that has guaranteed issue, pre-existing conditions, all those kind of things are waived, or guaranteed issues not waived, but the pre-existing conditions are if you've had prior coverage. This plan can work very well if you want to send your employees to the exchange and you want to get out of the group health coverage market, allowing the employees to have the choice of whatever individual market options are available to them, and you just give them a monthly stipend of cash or an annual stipend of cash to be able to, on a tax-free basis, be reimbursed for those premiums, and then they just go buy whatever they want. So it's a neat little option. It's something that people actually were pretty excited about when healthcare reform was originally put into place, but obviously they're pretty disappointed when the FAQ 11 came out. So now they're, again, excited that this option is available. As I mentioned before, there's a maximum benefit limit. So for an individual, the most that you can reimburse them through a QSEHRA is $4,950, or for family reimbursement is $10,000 a year. So that's the maximum that you can offer to them on a tax-free basis that they don't have to include as income to them. And just as I mentioned, these usually don't see a lot of changes here, but there is an inflationary adjustment. So if you look at like an FSA today, there's an inflationary adjustment for those as well. And so when the FSA got changed and the maximum going to $2,500, we're at $2,550 or $2,600. I mean, you're not going to see a big jump to this $4,950 or the $10,000. I wouldn't expect at least. These HRAs are not subject to certain compliance requirements. So if you're an employer of 20 plus employees but under the 50, you don't have to comply with COBRA with the QSEHRA. So you don't have to continue to offer this stipend after someone's been terminated, which I think is nice. It is still an ERISA group plan, so a plan document, summary plan description is still required. And the same terms to be eligible are required underneath for this QSEHRA. Now, you can, though, make an adjustment on the maximum benefit based on age and family size variation as far as the price of the individual policy. Okay, so that's unique. It's something that you could get involved in. I think that simple is really important, though, so you got to be careful when you start basing, because remember, individual coverages are based off of how old somebody is, and so you can make some rules and stipulation on the reimbursement level and how old they are is what they get paid, or it's like kind of a up to $4,950 kind of thing, but no more than X. And so just make sure this is simple, because if you're going to internally administer these things, it can be very complicated because you've got a different amount for every single individual if you base it off of age or family size. If you're going to find a third-party administrator to do it, that might simplify the process and get you out from underneath this. And so there's a lot of people that are trying to get pretty creative on ways to make this simple and offboard the administration. So exciting stuff there. And you can also include certain categories of employees, or exclude, I'm sorry, certain categories of employees. So, people within a collective bargaining agreement, part-time or seasonal don't have to be included, but people that haven't completed their 90 days of service. So when you think of the current waiting periods and the rules around that, it would still kind of apply. So you have 90 days, a maximum 90 days until people are eligible for coverage. And then also you can exclude people that are under the age of 25, which is kind of interesting. So those adult dependents, you don't have to include them. So that could be good or bad. It just kind of depends on how you want to set these up. Okay, so what I've done here now, we're getting close to the end of the presentation, is I've put together a comparison. People usually like this in the past when we're trying to compare, the differences between HSA, an HRA, a QSEHRA, and an FSA. So who owns the account? In the case of an HSA, the contribution to that, the actual individual employee owns the account. The reason why you know that is that if they're terminated, they take the money, they don't have to give it back. In the case of all the other plans, the employer owns the account. Okay. Who may fund the account? On an HSA, employers or employees can fund the account up to the maximum amount. In the case of an HRA or QSEHRA, the employer is the only one that can fund the account. In the case of an FSA, employer or employee can also fund the account as well. As we mentioned earlier, there's minimum deductible requirements on an HSA. and that minimum deductible in 2016 and 17 is $1,300. So if you're going to put an HRA with an HSA, you could buy a $5,000 high deductible health plan and start funding the deductible expenses after $1,300 if you wanted to. Okay. In the case of a QSEHRA, you do not have to have a group health plan. In the case of a regular HRA, you do. In the case of an FSA, those can be standalone as well. What's the limit on the contributions? In the case of an HSA, got those listed there. In the case of an HRA, a regular HRA, there's no actual limit on the amount that you can reimburse. Mentioned earlier as well, $49.50 or $10,000 is the current maximum on a QSEHRA. In the case of an FSA, you have a maximum of $25.50 in 2016 and $2,600 in 2017. Okay. Can funds be rolled over? HSA, HRA, QSE, HSA, or HR, I'm sorry. All those can roll over. In the case of an FSA, you have the carryover provision if you want to throw that in there, so it's not a full rollover of the amount of expenses. HSA, HRA, FSA, 213D expenses, all are eligible. On the HRA and QSEHRA, you're talking about ones that are defined, but in the QSEHRA, you're talking about an individual health plan premium is going to be added to that benefit. Okay. Everything needs to be substantiated. If it's an employer account on an HSA, it's the individual's responsibility to substantiate the claims and make sure that they're eligible. It's not your job to know that because those are individually owned accounts. And you pretty much can't reimburse for non-medical expenses except for an HSA, except they're going to pay a penalty. Okay. One of the things I want to mention real quickly is that when you're talking about a QSEHRA, you can't, if you have a current HRA and you're just going to switch over to this option, you do need to get a new plan document. It has to have QSEHRA language in there, which might just be as simple as an amendment, or what we're finding more often is people are just rewriting the documents just because they want to make sure that they have all the current language of what's going on inside the plans and not confusing the employees on the summary plan descriptions with the highlight documents. I know that was kind of quick, but we promised this session would last no longer than 30 minutes, and I think we're right up on that. If you do have questions, feel free to either reach out to me direct, or you can send an email to or message to our general inbox, which is myhealth@biginsurance.com. Call our direct office line, which is 360-695-3301, and ask for your favorite consultant here at the office to help you out with that. We have some dedicated folks that are graded individual coverage, and that's a lot of what they do. So we're more than happy to help out if this is something in the direction you're looking to go at.